afternoon, and good evening for whatever time you are watching this video. Welcome back to my channel. So today I am going to be doing a requested topic. This topic was requested by Tony Garcia 4898. He asked me to go over the court process a little bit more for case managers, child welfare case managers, because that was the field that I was in. So that's what I'm going to be talking about today. When a removal happens, when the child protective investigator goes into the home to take the child or the children out of the home, they have already spoken with the assistant state attorney to get sufficiency. So they have to go over the details of the case or the reasons for removal, and the assistant state attorney says either yes, we have sufficiency to remove the kids, or no, we do not. So that is the very first interaction of some type of court proceeding. So after that occurs, there's usually a shelter hearing that happens within the next 24 hours of the children being removed from the home, and that's where a judge is able to hear the facts of the case. And I do want to preface this and say this is for the county that I worked in, which was Pinellas County. This is how they operate. I don't know about how any other county works in the state of Florida or in any other states, but this is how our court process works. So the facts of the case are heard before the judge within about 24 hours. They hear the facts. They determine whether or not the children will continue to remain in the state custody. So the judge does hear that information, and they do make that determination, and typically parents are assigned an attorney right then and there, unless they've already, quickly quickly taken action to get their own attorney involved. But yeah, so they do get a public defender or attorney right then and there. So anyway, so then you have the shelter hearing, and that's where they determine, like I said, the visitation of the parents. That's when if there's a relative involved, they'll give them the court order saying the child is now in their custody, and there might be a guardian ad litem assigned at that time, and they're another party to the case that will just advocate for the children on just strictly behalf of the child's best interest. If the child has medications, the judge will go ahead and continue that order, or have it ordered for the department to review the medication. So the shelter hearing isn't that long at all. It's very quick and very short. And as a case manager, you typically don't go to the shelter hearing unless you have a new baby born into the case. But other than that, it's just a child protective investigator and the parents, and typically the children, unless they're under a certain age, that attends the hearing. So that is that court hearing. Then there is the case transfer staffing that happens with the parents and the case manager agency. So at this point, there's already another court hearing set. It is the adjudication hearing, if I'm not mistaken. That's the title of it, adjudication hearing. So that is set next, and it's already set. So when you go to your case transfer staffing, they'll give you the date, and in between that time, case transfer staffing and the adjudication hearing, that's when you as a case manager are supposed to meet with the parents, get background information, a little bit of history about them, determine what services are beneficial to help reunification occurs. You are supposed to have your case plan completed by the time you go to court. You should definitely have your referrals completed before that time. That's just like best practice, because to be honest, some parents, you're only going to see them at the court hearings. It's just how it works out. You try your best to meet with them once a month as recommended, but after that first hearing, sometimes you might not hear from them. So you want to at least be able to say, yes, I did give them a referral for the services that they were supposed to be court ordered to do. I did give them to them at that court hearing. So that's just best practice. Sometimes you will have another hearing after the adjudication hearing. I cannot remember the name of the hearing, but it's really just like a formality for the most part, and that's why it's not done that often. It's done here and there, but I know it starts with a D. I can't remember the exact name of it. I don't know if it's disposition or something else. Anyways, there's nothing really required for you to do there. So anyways, typically adjudication hearing, and usually they are right, like maybe like 2 weeks after shelter hearing is kind of the time frame that you can expect, but it varies. So anyway, so 2 weeks, around 2 weeks to a month after you've had the initial removal, and 6 months later is when you're supposed to have your judicial review. And again, these times aren't set in stone. They're not. They're flexible a little bit to some degree, but it's usually 6 months after. So in between this time frame, you're supposed to have been meeting with the parents once a month regarding their case plan tasks. If you're updating their referrals, so they go and get their psychological evaluation, that's a common one, and the evaluator recommends that they have individual counseling and parenting classes. So then you'll update your referrals to reflect a referral to parenting class and a referral to individual counseling. So you want to make sure that you're filing the referrals that you complete with the court. You're supposed to file that with the court. The assistant state attorney is supposed to be able to know exactly, what referrals the parents have been given. So before your court hearing, or just here and there, if things pop up with the case, you are talking with the assistant state attorney. You'll just kind of give them a progress of what's going on. If there's any issues that need to be brought up before the general magistrate, because that's who oversees, at least Pinellas County, that's who oversees the judicial reviews. It's not the judges, unless there is something, either one, there's like a status hearing and they'll combine them with the judicial review, or very specific cases. An example would be that needs to be brought up for the general magistrate is if the parent has somebody at their supervised visits that shouldn't be there, and that's something that the court needs to address and make record of. And if there is a order for that person not to visit, then that gets something that the assistant state attorney will need to know, and it can be brought up before the general magistrate, GM for short. Assistant state attorney, I'll just start saying ASA from now because that's what we call them. So those are what you're going to be doing, in between the judicial review. Okay, so judicial review. Now, they don't have the best reputation with case managers because, one, even if you're prepared for it, you never know exactly what the parents' attorney are going to bring up. You don't know what the parents are going to bring up. You don't know what the guardian ad litem is going to bring up. So you can have conversations with people before. You can call, check in, remind parents like, hey, you have this court hearing that's coming up. Did you have any questions? Did you have anything that you wanted to discuss beforehand? So you can do all those things and still get to the judicial review. And there's just something about it. People just like to throw case managers under the bus. It is infamous for that time. I don't know why, but that's how it is. So, I've had it happen where the guardian ad litem will say, hey, the child need these services, and they never even talk to you about needing those services. Maybe the caregiver talk with them specifically, like even though you're going to your home visits and you're asking them, they didn't specifically mention something to you, and they did to the guardian ad litem. So you have those instances where it's like, oh, I thought we were supposed to be on the same team at least, but nope. And you'll have sometimes the parents are saying that you didn't they miss visitation. That's a big one. That's like always one that you want to make sure like you have your documentation very clear on when it comes to visitation, because parents typically bring that up, that and they didn't send me for drug screens. So those are, like, I would say like the top two for sure that you have to make sure, in addition to, you know, where are they at with their services. You need to make sure you have answers and responses for why or why not they, reasons for why they did have a visit or they didn't have a visit, or what was the communication when it came to the random drug tests. So just letting you know, those hearings can be a little intimidating, and you are required as a case. I mean, this is why it's good to talk to the ASA before, because they can relay, you know, everything that's going on. But sometimes, you know, if those conversations can be quick, they might not have a lot of time to get all that information. So you will have to be welcome and ready to speak. And I wasn't the best at this, but there are some people that are really good. I wasn't the best at it because I have a hard time saying exactly what I wanted, what I'm trying to convey. Court definitely did help me over the years with getting better with that, because, you know, you're right there, you have to speak, and the GM is expecting it to be a clear answer of why. If not, they're definitely going to ask follow-up questions. So yeah, you will get better. That's one thing about this job, is that if you're really trying to improve on certain things, this job will help you, like speaking quickly on your feet, thinking on your feet, you know, adjusting to different situations, learning how to adapt, multitasking, being a quick learner. Like being a child welfare case manager will definitely help you in that area. So you have the judicial review, you have your points that you have to speak up about, you have to make sure that it's very clear what is the progress of the case, what is still needed for reunification to happen, what is how are the children doing, and displaying the whole all facets of the case. That's the time for the judicial review to happen. And typically you should, so this is one thing that I didn't really notice what was going on or supposed to happen when I first started, but so I'm going to let you know. So your agency should be having meetings before the judicial review. They're supposed to have them, I forget the time frame, but they usually should happen right before the judicial review, so that you know, as a case manager, what exactly is needed to move the case along. Because really, you're just a case manager. You don't really have the power to say, okay, this person, the parent, is now ready for unsupervised, they're ready for overnights, etc., etc. That is the determination of your supervisor, your assistant program director, however your agency runs, somebody up above you. So even though you're in court and you're saying, oh, okay, this is what is needed to move the case along, mom hasn't done this, they need to keep doing that, the supervisor or assistant program director, whoever is higher up, is supposed to let you know. And if it's not clear, you need to make sure that you're asking them, like, because it's you who is the person before the judge is the case manager. So you need to be able to understand why exactly the parent hasn't moved to unsupervised visits. And usually they will make it clear, but sometimes, you know, they have a lot of meetings, they have a lot going on. So you need to make sure you understand, have those meetings with your supervisor at least, and say, hey, before we go to court, what is it that's still missing, and yada, yada, yada. So you'll just keep having these judicial reviews in between your court hearings until it's determined one or two well, a couple of different things. Now we're just going to quickly talk about two different routes, right? So you have a parent who is doing everything that they need to be doing. They're displaying the behavioral change. And what I mean by this, if they were once in a domestic violence relationship, that was the reason for removal. Now they've gone to all their classes. That treatment provider is letting you know. They've, giving you feedback saying, hey, this person is understanding what we're talking about, and they will be successfully discharged from the class. The parent is no longer engaging with that partner, or if they are, they're that other partner has gone through their classes as well, and you haven't noticed any issues as far as observing their interaction. So you have to go back to court for unsupervised visitation, you got to go back for overnights, and you have to go back for reunification. So those are the next steps of the court, your next court hearings. And you'll have to file a home study with the court once you do it with the parent to do the overnight visitation. And so you have that parent. Once they get reunified, this case does stay open for 6 months with the agency, but you have that parent, there's no issues, they're not doing anything of concern, or if they are, they're addressing the issues, and everything's good. Your case is not closed. If there's no real progress on the case, then that's when the department is allowed to look at other permanency options outside of reunification with the parents. And so the reason why some cases stay open so long, like there's just some issues, or the attorney is able to advocate for their client and get more time extended. So but eventually some of those cases do end up going to other permanency goals. That includes adoption. That includes permanent guardianship if the child is placed with a relative or non-relative. And that includes APLA. Don't get me to lying, but essentially we use that permanency goal if there is like a teen that's in foster care and there was no family that is going to take them in, or they're essentially they're not interested in being adopted and they'll age out of foster care. That's when we use that permanency goal. If the goal is, permanent guardianship. If the goal is permanent guardianship, you're going to have to, have a conversation with the relative caregiver, and the parent, and they both have to come to the consensus that my child, as a parent, my child will remain with this caregiver until I'm ready to get back on my feet and reopen my case. And that's pretty much what that goal is supposed to do. It's supposed to allow the parents the opportunity to continue to work their case plan and get things done. And whenever they are ready, they have everything done, they can petition the court again and go back, reopen the case, and regain custody. That's what that goal is supposed to be for. And usually, if that's determined, it doesn't take long for the case to close right after that. The focus of the case now becomes, does the guardian have everything that they need in order to keep custody of this child? If the goal is adoption, then that's when you have two routes for that as well. You'll have a trial to terminate the parental rights, TPR, that's what it stands for. You'll have you'll either have a trial, or the parents will sign their rights away. And that does happen. So in my experience, I went to trial one time, and I've had maybe three or four separate cases sign their parental rights away. For whatever reason, they come to the determination within themselves, both parents, and they'll sign their rights away. That's done in a court hearing, in a court setting, to accept those signatures. But if you do have to go to trial, then you, as a case manager, even if you weren't assigned on the whole case, you are responsible for knowing everything that has happened in that case. Expected to know all the referrals that have been given, everything that has been done from beginning to end. Anytime the parent was supposed to meet up and they didn't meet up, anytime their visitation was missed. A trial is definitely very difficult and taxing, but it's something that case managers definitely don't look forward to, and ultimately it's up to the judge to determine where they will rule. I'll go into my experience with the court TPR. So it was very nerve-wracking. That was around the time that I really understood exactly what I was doing as a case manager, or at least like my participation in what I felt like was kind of separating a family, because that's what is happening. This is the biological parents of this child, and the court is determining whether or not they should be legally bound together for their future. So I was having a hard time understanding why exactly this was the process. But then I started reading through the notes. So if I'm not mistaken, the case had already been open 3 years prior to me being assigned to the case. And going through all the notes, not saying they had every case manager, they weren't on it. They weren't doing everything that needed to be done to but they weren't doing everything that needed to be done on the case. And that happens sometimes because us as case managers, we're responsible for so much. If you haven't checked out my video, everything that a case manager has to do, please check that out. It'll be in this case manager social worker playlist. At the beginning, there was a case manager who was going not above and beyond. She was doing her job. She was making sure that the referrals were given, and she was assigned for a good amount of the case. And so by the time I was there, I know I was definitely making my attempts to meet with this parent, but I was new, and maybe I might not have been as adamant if the parent just was like giving excuses and not kind of really letting them know like, hey, you need to meet with me, because if not, X, Y, and Z. So yeah, I definitely had my experience as well in trying to make sure things were taken care of as far as the progress of the case as well. So I reviewed those notes. I had a notebook of kind of important dates, how many referrals were given, and just like everything, how many visits were missed, all that stuff. But then I had printed out like all the notes of the case, and there was about a binder about this big of everything, of all the notes that were entered for the case. I had to be there for maybe 2 or 3 days, like full days, or maybe not full days, but like majority of the day was taken up, and I had all these other cases. So just keep that in the back of your mind. Anyways, I get up on the stand, and I had a good attorney. She was one of the ASAs that were really just like, whew, all right, she's tough. She is going to make you feel like a little bit of intimidation. So actually working with her on the trial is what kind of helped me like have a better relationship with her, because up until then I was like low-key kind of scared of her. So anyway, so she was I'm up on the stand, of course, sitting by the judge is right here, and it was very nerve-wracking. I'm not gonna lie, definitely very nervous, but there was an expectation. The ASA had already talked with me. She was like, you're a soft-spoken person, and for trial you definitely have to speak up and feel like confident in what I'm trying to say and everything. So she's just like, I remember her saying that a couple times. So I after the hearing, I know she did tell me I did a good job. So yeah, so there was they were questioning me as a case manager. What was this that happened regarding substance abuse referral, and what did you witness? And I just pretty much had to speak on behalf of all the case managers that had previously worked with the parent. And I remember the defender, he kept trying to question my notes, like the notes that I had, because I was able to have my binder and my notes right in front of me. And he just kept trying to like pick at it for whatever reason. Like, he was trying to, I guess, poke holes through my testimony or whatever, what have you. But like I said, the ASA, she wasn't having it, and she was like, no, she is the case manager. She is able to hold this binder. She was able to talk about the history of the case. So yeah, it was a long, I think I did 2 days of testimony, if I'm not mistaken. So I had one day fully just answering questions, and then the next day maybe not as long, but yeah, it was very interesting process. I never want to have to do it again. But I still do like the aspect of court. But anyways, so that case did end up, the judge did end up terminating the parental rights. And yeah, so then the next step is adoption. So I have the luxury of being an adoption case manager as well as a traditional child welfare case manager. So I did get to see both sides of the court hearings and proceedings. And on the adoption side, I don't want to say it's a coveted role and position, but you don't have the stress. I'll put it this way: you don't have the stress of having to meet monthly with the parents. So that is something that makes your job a little bit easier. And for the children that are with their relatives and non-relatives, there's not as much I would say you would need to do for them. Not saying there's nothing you don't have to do, but so yeah, so there's a lot of paperwork on the adoption side of things that has to be done. So you'll have your court hearings about the progress of the adoption, whether the child is already had someone identified as someone that will adopt them, like I said, relative, non-relative, or you have the cases where you have to make your efforts as adoption case manager to locate parents or to locate adoptive parents. And so you have to update the court about that, like we took them to a match meeting, or they've met the parents and they're going there for overnight visitation, etc., etc. So those are how those court hearings would go. And then the best of them all is the actual adoption hearing. By the time we get to adoption, the caregivers are very relieved. They're like, oh, can't wait to have my home back. Can't wait to just, if I want to take the kids out of state, I can take them out of state on a visit. Like, I don't have to have a court order. Just, they're very relieved and very happy for that day to come. The kids, a lot of them are little, so they don't really know necessarily 100% what's going on. But they smile and take the pictures. And in our county, the judge who typically has presided over the whole case, they'll give them a teddy bear and they'll take a picture. The court hearing for the adoption is very quick. It's not long at all. And honestly, people prefer it that way. Like, they're just, all right, let's get on to the next phase. So it's not a long court hearing at all for the adoption hearing. And like I said, the judge takes the picture with the kids, and it's just a light-hearted day. Like, those are the days you look forward to as a case manager. Those and the reunification days. Even the permanent guardianship days, because at that point, the child is in a safe place and their needs are being looked after. So those are the days as a case manager that you look forward to. Very rewarding. I mean, honestly, as an adoption case manager, you're having way more frequent days of adoption, because that's like that's your main thing that you're responsible for. So you have way more days going to court hearings and seeing the children being adopted versus the reunification. So those are pretty much, that's the whole completion of the case. There are court hearings if you have a teenager on your case that you also do have to attend. Usually they'll try to lump them in with the judicial review, so you don't have to go to court, a separate court hearing. But sometimes there might be a status of that that you need to follow up on. And essentially what they're expecting, the GM is wanting to know, is the child prepared to be an adult, essentially, even if they're with a relative or non-relative. So it's really mostly on them, the caregiver, but as the case manager, you need to make sure you know exactly what's going on. This includes like their driver's license. Do they have their social security card? Have they gotten their records from their primary care provider? Do they know who their primary care provider is? Those are some of the things that you have to be prepared to answer at those type of court hearings. As I mentioned earlier, if you have a new child born into the case, so there's other children that have already been removed, mom is pregnant, has a baby, then you'll have a court hearing to address that. Like I said, you'll have status hearings. So if you were a new case manager taking on the case and something was supposed to have been done, and then the judge is like, okay, you don't know, like, you didn't have a chance to review, you don't know what's happening right now, so we need to have a status hearing to make sure this item gets done. Out-of-state travel, usually you'll try to talk with the caregiver beforehand so it can be done all in one hearing, but sometimes you have to go to court for that, and especially medication. If a child is on medication, you'll have separate hearings for that. So if you're one of your children in your case, if they have any juvenile justice hearings, you also have to go to those as well and be a part of those hearings. Oh, I think I did have to go to truancy, like if the child was placed with, I think I did maybe like one time, if the child was placed with the parent. Maybe, I don't know. Truancy is ringing the bell for me. So yeah, there's truancy hearings, juvenile justice hearings with the, if the child has charges that they've gotten on their own, you need to make sure that they're there, and you as a case manager need to know what the follow-up is and such. So those are additional hearings that you're responsible for attending. And then also, if there is something major that goes on in your case, say for instance, the parent had overnight visitation and you do a pop-up visit and parent is not supposed to be there, is there, or some type of concern, so you have to step the parent down, then that's another court hearing. So probably back, it's like starting back at one almost. It's so hard to do those hearings, because like now you're to a point in the relationship with the parent where it's like, okay, well, you got here, we had a good working relationship, you hit this, it was going on for X, Y, and Z long, and now it's like, now we still have to continue to work with each other, but now we have like this little tension going on because you were being sneaky and untrustworthy. So yeah, those hearings there's gonna be a lot of tension. So overall, I will say that court is an interesting experience. I enjoy going to court, even though every time, for the most part, I was nervous up until like the end when I was on adoption, and pretty much like those are the easiest ones when the child was with a caregiver. But like I said, you will learn skills. You will learn how to speak well. You'll learn how to speak up. You'll learn how to advocate for yourself, especially if someone is trying to say you didn't do something. No, yes, I did. Here's my example. And you'll know how to convey exactly what is going on with the case in a concise manner. Like I said, you'll learn how to ask questions if you don't know. It just teaches you so much, and it is an important aspect of the child welfare system. So overall, that is a nutshell of the court hearings and the proceedings that go on as a child welfare case manager. Let me know down in the comments below if you are a case manager already and you have to attend court. What is your favorite thing about court? Or let me know after you heard everything that I described, what would be your most intimidating part of court? I'm very interested to know exactly what are people's experiences with court, maybe outside of child welfare too. So you can leave that down in the comments below. If you have any comments, questions, or critiques, you can definitely leave that down below, and I'll catch you all in the next one. Bye.